The rules of corporate governance determine who manages a corporation. In the United States, statutes provide that the business of a corporation is to be managed by its board of directors. In the old 1906 case, Automatic Self-Cleansing Filter Syndicate Company versus Cuninghame, the Court of Appeal of England and Wales considered whether a corporation's board of directors was required to carry out a resolution that was passed by a simple majority of shareholders. The Automatic Self-Cleansing Filter Syndicate Company was an English company that was incorporated in 1896 for two main purposes. The first was to acquire inventions in the filtration, treatment, purification, storage, application, distribution, and use of liquids from James Wilson. The second was to sell its inventions, or any part of the company, to another similar company. Under Automatic's Articles of Association, the authority to manage the corporation was vested in a board of directors. In addition, under the Articles of Association, directors were appointed by shareholders and could only be removed by an extraordinary resolution, which was a vote of at least 3/4 of the shareholders. Further, directors were empowered to do anything the corporation could do that wasn't required by statute or under the articles themselves, subject to, quote, regulations as may from time to time be made by extraordinary resolution, unquote. In January of 1906, a shareholder meeting was held based on a request by A.H. McDermott and other shareholders, who collectively owned 55% of Automatic's outstanding shares. The purpose of the meeting was to vote on a resolution for the corporation to sell its assets to another company. But at the meeting, McDermott and others weren't able to secure the vote of at least 3/4 of shareholders. Instead, only a simple majority of 55% of shareholders voted to pass the resolution. The meeting was then adjourned, and the directors declined to comply with the resolution, believing it wasn't in the corporation's best interests to sell its assets. Subsequently, McDermott, on behalf of himself and other shareholders, sued Automatic's directors in county court, seeking to force Automatic's directors to sell the corporation's assets. In the action, McDermott moved for an order asking the court to force the sale, which the court refused. McDermott then appealed the decision to the Court of Appeal of England and Wales.